Just to introduce myself, I'm Laura Molloy. I'm a Senior Associate Employment Solicitor here at Mills and Reeve, and I'm joined this morning by my colleague Alexandra Byrne, who's a fellow Senior Associate.
Hi, everyone.
So obviously we're here today to discuss managing sickness absence. What are we going to cover today? So we're going to cover getting your policy right. Policies are a key part in operating a fair absence procedure, whether for short or long-term absence. So we'll be discussing that. Obtaining medical evidence, which is another key part of a sickness absence process. We'll run you through some of the detail on how to do that and what the benefit is of doing that. Managing a phased return, particularly in long-term absences, that becomes an issue, and we'll have a look at what that can involve and where suggestions for useful phased returns might come from. Mental health, which is becoming it's a prevalent issue for employees and therefore for employers. So we'll have a brief discussion about mental health. And finally, we'll be looking at the issue of employees who refuse to engage in a process, because employee engagement is a huge part of being able to manage somebody's absence and get them returned to the workplace in the best way possible. So we'll look at some problems that can arise with employees who refuse to engage. So firstly, I'll be handing over to Alex, who will have a look at getting your capability policy right.
Thank you. Yep. So as Laura said, to start with, we're going to look at getting your capability policy right. So there are a number of reasons why you want to have an effective sickness absence policy in place, and there are a number of key things that it should cover. So it's a legal requirement that terms and conditions relating to sickness and sick pay are given to employees in writing. Now, this can be in a Section 1 statement, which is typically the contract of employment, or it can be given in a separate document. So your policy should cover when and how to report sickness absence and what information the employee should provide about why they're off. It will also need to make clear when the employee will need to provide you with medical evidence. Many employers, probably likely many among you as well, require self-certification for up to 7 days absence and a fit note after that. And these are also the requirements for statutory sick pay purposes. Now, there's no obligation to pay sick pay over and above statutory sick pay. If employers choose to pay company sick pay, they can choose how long they want to pay it for, how it's to be calculated, and any conditions attached to the payment. This is all really important information that you should cover in your policy. Your policy should also set out the procedure for managing long-term sickness absence. It should cover the stages to go through, the meetings that will take place, and what will be considered in each stage or meeting. Having an effective policy in place will help you to deal with absences consistently and effectively, as well as putting employees on notice of the standards of attendance and reporting that you expect from them. This in turn will help to reduce legal risk for you.
So what are the types of sickness absence that you might encounter as employers or people managing employees? Firstly, you've got your sort of more typical one-off short-term sickness absences. These are things that, it might be a day or two, and it might be for, a headache, a sore throat, that sort of thing. And then you have absences that are short-term but are more persistent, which tend to fall into two categories: either regular absences for unconnected minor ailments. So somebody's off quite a lot for short amounts of time for things like coughs, colds, stomach bugs, or persistent short-term absence that is due to a recurrent condition. So they're off a lot, but it might be because of the same reason. And finally, you have long-term absence. So your own policy within your company will define what that looks like in terms of number of weeks, but these are your lengthier absences, which tend to give rise to sort of more difficulties in terms of managing the absence and sort of trigger the need to take medical evidence very often. But if we start with short-term absence and how to implement a fair procedure, essentially. So what is a fair procedure will often depend upon your particular company's policy. That's your starting point. What is the policy, and what does it say about how you handle sickness absence? But in general terms, following a fair procedure for short-term sickness absence tends to involve making sure that an employee is aware of the level of attendance that is expected from them and what the impact is of colleague absence on the company itself and other colleagues. And particularly importantly, what are the consequences of continued absence? Obviously, you would look back to your company policy, but normally what would happen is formal action that can have sanctions attached to it, anything up to dismissal. Depending on the particular situation, and it is important to look at each case in its own right, but you will need to be identifying patterns in the absences and investigating the reasons for those patterns. Now, that might be either because there is a potential underlying condition. So if it's looking like people are off quite often, but for similar or potentially related reasons, that is a pattern, and that merits further investigation. And also patterns in absences themselves. So if people are always absent on a Monday or on a Friday, that takes you down a slightly different process, which is outside of the context of today's discussion. It's more of a disciplinary issue, but it's something to keep an eye out for. When you're looking at patterns of absence from a medical perspective, i.e., might there be an underlying health condition, this will likely involve you taking medical evidence and consulting with the employee. Both of those things are key to any sickness absence process. It's getting input from the employee themselves, and also from, when it's necessary, from medical experts, whether that's a GP, Oc Health, or a treating physician. You're going to want to establish from a combination of those things when attendance is likely to improve, and just keep in contact with the employee. And obviously, and we'll talk a lot about policies today, you need to be familiar with your company's policy and what its trigger points are. And then if we move on to longer term absence and how to follow a fair procedure there, again, follow your organisation's policy, but that will tend to focus on the key points on the slide. The first of which is ascertaining the up-to-date medical position. We're going to look at that in more detail in a moment, so I'll move past that to consulting with the employee. So this is key in both short and long-term absences, but you'll want to meet with the employee, discuss their attendance, look at any steps that might be taken to improve their attendance and facilitate a return to work. And the employee should always be offered the opportunity to ask questions and also discuss or challenge the evidence. So if you receive medical evidence, for example, that the employee doesn't necessarily agree with, it's important to take on board what it is the employee is saying, and make sure that that's considered in any considerations as to next steps. You might want to you will have to look at considering reasonable adjustments with long-term absence. There is potentially a natural link between the length of time somebody is off work and the potential for them to meet the legal test of disability. So when that is triggered, when an employee is or is likely to be or even might be disabled, you will want to consider whether there are any reasonable adjustments that you can make to facilitate their return to work. And that can look like a number of different things. It can be changes to the workstation, to the location, to the hours, to the duties. It can come in many different forms. But it's important to consider because it is a legal obligation if there is a disability involved. You will want to consider the availability of other roles and look at redeployment. Is there another role that the employee is qualified to undertake? And you'll want to include that in any discussions that you have with an employee in a long-term absence situation, to take their view in it. Sometimes employees are interested, sometimes they're not, but at least as an employer, if you've considered that, that is part of a fair process. And then you also want to consider the availability of any permanent health insurance or ill health retirement provisions in cases of particularly lengthy long-term absence. After you've looked at all of these things, it might be possible to consider dismissal on the grounds of capability for ill health. That will very much depend upon the individual situation. So things like how long they've been off, when or if they're expected to return, which tends to be something that is commented upon in the medical evidence. What's the nature of the illness, the employee's particular role, and whether it can be or is already being covered by somebody else, and the nature of the employer's business. Something that's relevant here is the size of the employer, because obviously in a smaller company that might have 5, 6, 10 employees, that can make it a much more difficult exercise to cover somebody's role on a long-term basis. In a bigger employer, there is potentially more chance to redeploy employees from other departments to cover the role for longer. And all of these sorts of considerations play into whether a fair decision has been made when looking at potentially terminating somebody's employment. Overall, the key risk really is disability discrimination. So, and it's important to be proactive in that situation, not reactive. So you're not waiting for the employee to tell you what they need, what would help them. You want to be actively exploring that with the employee and asking questions. Alex will look now at obtaining medical evidence.
So yeah, we'll just revisit the point about obtaining medical evidence. So you might want to obtain a medical report during employment in several circumstances, including to assess an employee's fitness to work, to consider whether an employee who has taken a substantial number of short-term intermittent absences might be suffering from any underlying medical condition that links all those together, to obtain a prognosis concerning the likely timescale within which an employee who is on long-term sickness absence might be likely to return to work, to help determine whether an employee is suffering from a physical or mental impairment which might meet the legal definition of disability in the Equality Act, to help determine whether there are any reasonable adjustments that you might be able to make to help the employee to do their job or to avoid workplace disadvantages, to help with redeployment. Laura mentioned that's something to think about. If they're not able to do their current job, what duties are they able to carry out? Is a particular alternative role that you've already identified suitable for them? And then finally, to consider whether an employee might qualify to receive benefits under a permanent health insurance policy. So critically, you must get the employee's permission to approach their GP or consultant or refer them to occupational health. So who should you ask for a medical report? Typically, you might approach the employee's GP or consultant for a medical report, or you might refer them to occupational health. So on the slide here, there are some considerations that you might take into account when deciding who to approach. For example, the employee's GP or consultant might have a greater knowledge of their medical history, and the employee might also be more willing to obtain a report from them. On the other hand, their doctor isn't going to have any knowledge of employer practices and will approach the report purely from a health perspective. Obtaining a medical report from a GP or consultant is also governed by the Access to Medical Reports Act 1988, sorry. So there's a more detailed procedure to follow when you are seeking one, and that's mainly around consent. Occupational health, on the other hand, can give a more workplace-focused opinion, and it might be quicker to obtain a report from them rather than a GP or consultant. It also might be more expensive. Occupational health reports aren't covered by the Access to Medical Reports Act, so it can be simpler to obtain one. It's worth bearing in mind that the information from an independent specialist who hasn't previously been responsible for the employee might be seen as being more reliable than information from the employee's GP, just because they do kind of have that independent element. You should ensure that any request for a medical report is focused and limited to the information directly relevant to the particular purpose for which it's obtained. It's good practice to list the points relevant to the questions that you have. So, for example, their absence dates, their health condition, and what their role involves. So that could be, for example, detailing their responsibilities and tasks that the condition might affect. Things like standing for long periods, sitting for long periods, heavy lifting, driving, using a keyboard, etc. You should then list the questions that you want to know the answers to. Typically, we see employers asking the question of whether somebody is disabled, and in this case, it's often best to split out questions by reference to the legal test for disability, and that's so that you can make the assessment yourself based on the information provided, rather than the medical professional just answering yes and you not knowing how they've reached that conclusion. And you would do this by saying, for example, how long have they suffered from the condition, and what is the effect on their ability to carry out their day-to-day activities. Remember that although medical evidence helps to guide you, decisions relating to sickness absence remain managerial. That's for the company to decide on. And Laura's going to talk about managing a phase return.
Yeah, thanks, Alex. So managing a phased return to work, this often kicks in when you have had a long-term absence with an employee. Um, if they've been absent for a long period of time, you're likely to want to talk to them to plan for their return to work. This could include a phased return, which might facilitate their return to the office, and it could look like a number of different things. So it could be reduced hours, which gradually build up over a period of time, or it could be doing different work that is slightly different to their usual role, or doing the same work but sort of like lightening it somewhat. And we've included other examples on the slides, but things like different workstations or providing training and mentoring, these can all factor into a phased return to work. It's anything really that would help the employee to return, and gradually build it up over time, and to have a plan and a timescale over which to do that. So some practical tips. The first of which is we would strongly suggest reviewing the medical evidence, and looking at any fit notes that you have. Have a look at what they say about fitness for work. Have a look at whether they specifically mention a phased return. Look at whether they comment on whether the employee's condition will affect what they can do, or provide any recommendations if not. Even if a phased return isn't mentioned in the fit note, and the fit note simply says fit to work, that doesn't mean that it doesn't give carte blanche essentially to require an employee to return on day one to full duties at the usual contracted hours. It's something that you can discuss with the employee, and you can agree it informally with them. It doesn't have to be recommended. And this is part of that proactive approach that I mentioned earlier. Not just sort of sticking to the letter of what does the medical evidence say, but speaking to the employee and genuinely engaging with them about that. When discussing with the employee, you'll want to agree some logistics. So agree what that phased return will look like. Again, proactively consider what adjustments might be needed in the short term to facilitate the return, and explore those with the employee. And it will very much depend upon the employee's particular health prognosis. A more obvious example might be an employee with a broken leg, may have mobility problems. It might be something as simple as moving their workstation so that they don't have to walk up flights of stairs. If they are suffering from a condition that leads to extreme tiredness, that they're exhausted, you might want to look at exploring later start times. They can be very simple adjustments, but very effective at allowing the employee to return to work. A slightly different, so there is a phased return, but there is also reasonable adjustments, which, as I mentioned earlier, are a legal duty if an employee has a disability. Making those adjustments goes a long way to discharging that duty. So things like I mentioned about looking at different workstations or start times, and it shows the employer's managed procedure properly in the event that there is eventually a dismissal and a subsequent claim. When discussing with the employee, you want to agree the length and perhaps prepare a schedule. That will have to remain under review, and the next 2 points cover on this. So you will want to regularly review how it's going, how the employee is finding the return to work. Is the phased return or the adjustments that have been made, are they working? And is there anything else that you can do? Reviewing that regularly and remaining flexible are key. So it's far from unusual actually that an employee will return to work after a long-term absence and suffer a relapse in their condition. And that might mean that they need to take more time off, but it might also mean that an initial plan or an initial schedule for a phased return needs to be revisited and tweaked, and that alone might allow them to return in the workplace. So just meet with them regularly, identify any changes that might be necessary, and just continue to refine the plan. It's key to remember that you might need to take updated medical advice. So, relying on an occupational health report that might be from 6 months ago is not necessarily reflective of the current position. So if the situation calls for it, perhaps refer back for more medical advice. And also be clear about pay, because if an employee is working shorter hours, be very clear with the employee whether they will still receive their full pay or if their pay will be prorated to the hours that they have worked. It's important before having that discussion that you revisit firstly the employee's contract and also the company's policy to see if they mention how pay might work in that situation. Often they won't, and it will be a case of agreeing something with the employee and making sure that if there has been a change to the contracted terms and conditions, that they have agreed to that, and preferably in writing, so that there's no room for dispute down the line. And that's because there is a risk that there is a breach of, not only a breach of an express term of the contract, but also a potential breach of the implied term of trust and confidence. And that might lead to a resignation by the employee and a potential constructive unfair dismissal claim. And the other main risk is a disability discrimination claim. In practice, the main issue to consider is the general fairness of the approach, which will depend upon the circumstances of the return and also whether sick pay has run out. Alex will now talk about employees with mental health conditions.
Thank you. So you must obviously treat mental and physical health as equally important. The government guidance sets out that mental health is an umbrella term used to describe a range of conditions, including depression, anxiety, stress, eating disorders, and phobias. Poor mental health can result in a wide range of symptoms, treatments, and support requirements. Poor mental health can be long-term or result suddenly from a specific situation, such as a bereavement. It may or may not be related to the work that people do. Some conditions, like stress, can be worsened by circumstances at work. Proactive management is key with mental health conditions. How managers approach a period of sickness absence is really important to how effectively and quickly the employee will return to work and get back to their best performance. You should keep in regular contact with the employee who is off sick because of a mental health problem, particularly if their absence is longer than a couple of weeks. Regular contact is important to help prevent isolation, to support them whilst they are sick, and to help with their return to work. You should agree with the employee how you will stay in touch with them and how frequently. Is it going to be by email, phone, or face-to-face? But you should make sure that the employee agrees to the contact and that it's not overwhelming. You should consider whether their poor mental health is because of work. If so, you should try to resolve this. Stress-related concerns will need to be dealt with particularly sensitively. Medical advice is likely to be even more important, especially if the employee finds it difficult to articulate what their condition is and how it affects them. A wellness action plan can also be helpful to understand how their mental health impacts them at work. And in this respect, the charity Mind has a helpful guide that you can download if you're interested. A return to work meeting is part of a supportive process to help the employee make a successful and also a lasting return to the workplace and to address any ongoing health needs. It shows them that they have ongoing support from the company. If an employee's mental health problem is a disability, you could reasonably be believed to be a disability, you must make reasonable adjustments for them. And then finally, you should plan their first day back. So people are often very anxious about returning to work. You should support managers to make the event as trouble-free as possible for the returning employee. Give thought to how they'll be supported and reintegrated back into the workplace, whether that's in the physical office or working from home. And you should continue with this support during the first couple of weeks of their return. Knowing how to approach and talk to an employee who has a mental health problem might seem really difficult. You should talk in private and arrange that in advance. Be flexible about when and where that might be, and approach the conversation in a supportive and positive way. Questions should be simple, open, and non-judgmental to give the employee ample opportunity to explain the situation and their feelings in their own words. There are some examples in a guide for managers developed jointly by the CIPD and Mind, and these are on the slide here. So they include questions like, how are you doing at the moment? You seem to be upset, under pressure. Is everything okay? Is there anything I can do to help? Have you spoken to your GP or looked for help anywhere else? What support do you think might help? And then what would you like to happen and how? If absence becomes an issue, follow your policy and handle it in a similar way as you would a physical condition, subject, of course, to any necessary adjustments to take account of the fact that it is a mental health condition. If the employee's condition amounts to a disability, reasonable adjustments will need to be made. However, even if the employee does not have a disability, where mental ill health or work-related stress has been identified, you should consider adjusting your process. Any adjustments should be recorded and reviewed regularly. And then I'm just going to quickly run through some adjustments you might consider. I'm conscious of time. So you might consider flexing your trigger points. So that's adjusting your policy, being flexible with the triggers in there for absence so that someone's not disadvantaged by taking absence when they're unwell. In extended phase return, support someone to build up hours gradually and continue their recovery. Taking a sensitive approach, the tone of communication is really important, as we've already covered. Allow the employee more time. It might take them longer to reply to letters. They might need to be prompted or remind you about deadlines. And it might also be reasonable to extend the timescales between warnings or cautions before proceeding to dismiss them. Allowing a friend or relative to support them in the meetings rather than the usual trade union representatives or a colleague, and then holding meetings at an alternative location, for example, their home or a neutral location. And importantly, you should take any other steps reasonably required to allow the employee to fully participate in the sickness absence process. And Laura's now going to talk about employees who refuse to engage. I've seen a few questions about this.
Yeah, so this is a really commonly faced hurdle in the sickness absence process. I am conscious of time, but it's an important point, so I'll run through it. So we've listed some examples on the side of potential issues you might encounter. So employees who refuse to give medical consent, employees who fail to turn up for appointments or meetings, they might withhold information from you. There's a lack of insight into the medical condition, and also employees who raise grievances. So in terms of employees who refuse to provide medical consent, have a discussion with them. Try and get to grips with what the reasons are for refusing and see if you can address those concerns. It might be that they're worried about something as straightforward as confidentiality, in which case you might be able to explain to them who would have access to the information, how it will be dealt with, the fact that it will be treated in confidence within the people that you have outlined to the employee. And also familiarise them with your data protection principles as an organisation. That alone might allow you to sort of proceed with taking the medical consent. Also explain to the employee why you require a medical report and what the extent of the information is that you require and the consequences of that refusal. And I think the key is to be patient but firm, and getting across the point that this information is being required in order to assist the employee. You can only make decisions about employment based on the information that you have to hand. And if the employee will not allow you access to that, then you can only make decisions based on what you see. And it's just fairer and easier for all around if you have medical input, which helps to inform those decisions. In the case of an unfair dismissal set of proceedings, a tribunal will look at the attempts that you made to get the employee's consent, your reasons for requiring the report, and also the employee's reasons for the refusal. So this is part of an overall test of fairness. If an employee fails to turn up for appointments and meetings, again, talk to them, find out why, see if you can get, how can you get around any problems that might allow you to progress with managing absence. Could be something as simple as an adjustment to where you hold meetings, where you hold appointments, how you hold appointments. Are they remote? Are they in person? Look at all the options, see if you can find a way that works for both sides. It will depend on the circumstances and the employee's reasons for non-attendance. Also the medical evidence and how many attempts that you make to meet with the employee. These will all be things that an employment tribunal will look at in the event that you ultimately dismiss the employee and they bring unfair dismissal proceedings. If the reason for not attending a meeting is the illness or disability itself, you should generally adjourn and reschedule. Obviously, there's only so many times you will be able to do that, but certainly if it's within the first couple of times, then that's what you would be expected to do. Withholding information, again, you can only help based on what you know. So speak to the employee, be sensitive, supportive, and understanding. Always assume that anything that you put into writing will be scrutinised down the line. It sounds cynical, but that's the best way to present your documentation. So how would you feel if that particular correspondence were to be looked at by a judge? Lack of insight into the medical condition. So separate and independent medical advice is particularly important in those cases. So that's why it's, and we've talked about it a lot, but that's why it's key to get medical input. Grievances, it will depend upon the nature of the grievance. You want to try and keep the sickness absence process and the grievance process separate if possible. You're likely to want to deal with any grievances first before coming to a decision on the sickness absence and future employment, but it will be very fact specific. And finally, if relationships are strained, just think about whether involving a third party or a mediator might help the situation.
So apologies for overrunning very slightly there, but with that, we'll turn to some of the questions in the chat box. If you have more questions, please feel free to drop those in as well. We've had quite a few, so as we said at the beginning, we'll try and get back to you after the session because we'll only have time to answer a handful here. One of the questions we've had in is one person has been advised to take timeframes for both short-term absences and long-term absences. As these have previously been challenged in court, they say saying it should be tailored to the employee. So I think that's taking timeframes out of their absence policy. The issue they now have is the policy is very light with limited guidance, states what the process is, i.e. managed at stage 1, stage 2 final hearing, but no suggested timeframes or scenarios. What would our advice be? So, I mean, I think that the crucial thing is here, our advice would be that your policy should have timeframes in it. It's very useful for you to be able to have, and for your managers to be able to have that set of guidance that says when meetings should take place, how long the absence can be tolerated for generally. That gives you certainty, that gives the employee certainty. I think the point that's being kind of got at here is it's important to make reasonable adjustments for employees with disabilities. So your absence policy can say, a stage 1 meeting will take place after, for example, a month of absence. If you have an employee who's off sick for a disability, you may well decide to adjust that policy and extend that time frame. So we would suggest that you have a policy that sets out timeframes, but you must always bear in mind it might be reasonable in some circumstances to adjust those timeframes and not necessarily stick to it rigidly. The next question we have, Laura, if maybe you want to answer this one. So someone says, what steps should be taken if an employee has patterns of absence that should be treated as misconduct?
Yes, it's a good question. You need to explore carefully. Your records will show if the absence is regularly happening. As I said earlier, it might be that the people are being absent surrounding a weekend or at a particular time of year. It's every Christmas, that sort of thing. You would operate it as you would operate a misconduct, a disciplinary policy. And so that involves investigating, seeing if there's a case to answer, and then moving forward to a disciplinary hearing if there is a case to answer. It can be difficult because the employee will almost certainly deny that that's the case. But as with any other potential misconduct situation, you're entitled to make a decision based on the account that you prefer. And if you ultimately decide that it is very odd that an employee is always absent on a particular day, then it might be something that you perhaps issue a warning for. And if there is a live warning, then a final written warning. But it's operated like any other disciplinary situation.
Thank you. And then a few people have asked similar questions. So if you offer to redeploy someone to a role which is below that level, below the level the person is currently on, and they accept, do you need to retain the same salary, or are you able to reduce the salary to the role being offered? So typically they won't have a right to retain their existing salary. It's not a hard and fast rule, so you need to kind of treat it with caution. The reasonable adjustment that you'll be making is redeploying them into a different role. If the employee were to bring a disability discrimination claim in the tribunal would look at, would it also be a reasonable adjustment for them to retain their pay in that lower role? And this is going to depend on the specific circumstances. I would envisage it's going to depend a lot on what the company does in other situations. If redeployment for a reason other than disability comes with a kind of pay protection, then it's probably likely going to be reasonable to maintain pay. But as a general rule, it's unlikely that a tribunal would find that it is reasonable to also maintain their pay. So look at it in each individual case, but generally it won't be the case that you have to maintain their pay. And then one last question before we wrap up. So how should we respond to an employee who has an undiagnosed mental health condition? Can we insist on medical evidence to prove a diagnosis? Laura, do you want to take that one?
Yeah, so you can't force an employee to go to a medical practitioner. It's a really delicate issue, obviously, and you will also have to be aware of your own sort of obligations in terms of health and safety and safeguarding. You can look at your company's policy and you can look at the employee's contract and see what they say about the company's ability to require them to go to a medical expert. Often a contract won't comment upon it, and if it doesn't, then you don't have grounds to force that. Even if it does, frankly, whilst it gives you a little bit of leverage to sort of point that out to the employee, you can't ultimately say that they are committing an act of misconduct or gross misconduct by not going to a medical expert. You can only, and as we raised in the seminar, you can only make decisions based on what you have. And if you encourage the employee to go to a medical expert and they won't do it, then you have to make a call based on what you have observed, and operate a process in that way and ensure that you are fulfilling your health and safety obligations.
Right, so with that, we will wrap up. Our next webinar, not one in this series, but our next webinar is going to be on Tuesday at 10 a.m. And that will look at the new employment laws the Labour government is likely to bring in soon, so incredibly topical. We'll discuss the changes, what the changes are likely to be and what they'll mean for you, and what steps we think employers should be considering taking now. And then the next and final webinar in this series will be on the 24th of September at 10 a.m. And that's going to be on the topic of navigating statutory leave. So it will look at the practical implications of recent changes to the obviously quite complex rules governing family-related leave, so including things like carers leave, protecting new parents against redundancy, the new flexibilities in paternity leave, whether you should be reassessing contractual enhancements, and further changes which are in the pipeline. And our speakers, I'm afraid my PowerPoint has just crashed. There we go. Our speakers for that are Rebecca Cockerill and Hattie Martin. So thank you very much for joining us today. Please feel free to contact either of us if you have any further queries. And as I said, we'll try and get back to the questions that haven't been answered in the question box.